Good afternoon. I just want to get this out of the way. Nobody gets to die today. So, or this week, or even this month. Let's just say that. So this is just an opportunity for you to learn about or hear about the things that need to be taken care of at the end of your life. Some of those things can be handled now, and so in preparation. And I see that a few people brought family members. We welcome you because all of this is important information. At the very end, I will talk about what Pennyburn does at the end of life. But before that, we have 4 panelists, and I told them today that they could just introduce themselves because I think they can do that better than I can. But they are all professionals that work with older adults in different ways. And so I think that you'll find hear a lot of good information from them. And after each one of them finishes, you'll have an opportunity to ask questions of them. So be sure to raise your hand, and we will do our best to repeat that. The one last thing I want to share with you is we are recording this today. So just be aware of that. We'll see how it works. This is the first time we've tried to record something using our system. So hopefully we'll be able to make this available to you and to others in the future. So we will get started. Just don't trip over
I like the way you introduced me, too. It sounds better coming from somebody else. Good afternoon, everyone. My name is Robert Gallert. I'm with First Bank's Wealth Management Division. A little bit of history about me. I'm old. I've been in this industry for almost, actually 35 years. I can't believe it. Just want to share a few thoughts from our department and just talk about a few things that we think are important when it comes to estate planning, legacy planning, and why you should plan, which I'm assuming most of you guys have done some planning in the past, so a lot of these things you'll probably already know. But some of the reasons that a lot of people use estate planning, wills, trusts, beneficiaries is one of the first and key things is to avoid probate. Another reason would be to just simplify the estate and make it more efficient for the heirs. These are things that I think are important, and if you've dealt with some of the counties that our lawyer friend over there has, you'll quickly realize that some of the counties around here are a little bit slow when it comes to probate. And why is this important? If you go back to COVID, the one thing about Guilford County in particular is it was closed for 8 months and you could not do any probate work. So if you were in that process, it got shut down completely. So if we can set things up or do things where you can avoid those situations, I think it makes a lot of sense. Let's see. Some of the ways that you can set things up, or I'm just kind of break things down a little bit. A lot of people use brokerage accounts, bank accounts, annuities, life insurance. How do you set those up? It's probably one of the most frequent questions that we have. And I'll kind of start it from how it's already set up, and do you need to kind of move it to something else? When it comes to bank accounts, as long as you have a POD on the account and if it's jointly held, what will happen is upon a decedent's or a person's passing, it immediately becomes the property of the remaining person. If you have a POD on the account, you can actually place the trust there as opposed to having a beneficiary or an individual as a beneficiary. It simplifies it because it basically is the trust itself anyway. I've had a lot of clients come to us and say, do I need to go ahead and transfer everything out of my name into the trust? And the answer for us has always been no, you can just list the beneficiary as the trust. Yes, ma'am.
What's a POD?
Oh, good point. So the term POD, TOD, beneficiary, they're all the same thing. POD is a banking term, paid upon death. TOD is a brokerage firm term called transferred upon death, and then everybody knows the word beneficiary, which is the term that insurance companies use. It's all the same. It's just everybody has their name for it, I guess you would say. Why is a trust important? One, because you can actually avoid probate, but also it can be used for intangible items, cars. I have a client that actually owns a tank, and his tank is literally part of his trust. So it's a way for him to pass that without having to go through probate to his kids. I don't know who would want it, but I mean, I guess if you're a kid, you get a full-size tank to take home with you. Let's see, some of the ways that we see on the bank side that are way things are paid, set up is if you're husband, wife, most people set them up jointly. If something happens to one of them, the bank or First Bank asks that the other person come in, and what they'll typically do is either take that name off or they'll open up a whole new account, and basically you have a single account. But we do recommend, with husband and wife, we think joint accounts make a lot of sense, and it's pretty seamless. Insurance products, a little bit simpler. It's just a letter saying, please renew this person, I survived them. A lot of insurance companies will sell a lot of paperwork in the mail. Most of it is not necessary, but for all sense and purpose, all you're doing is removing somebody's name. Brokerage accounts, whether it's Merrill Lynch, us, Wells Fargo, this is industry-wide. If you have a brokerage account that's in joint name, you will have to open up another account. There's no ifs, ands, or buts about it. They literally cannot remove people off accounts anymore. You have to open up a whole new account and transfer everything into the new account. Now, everything from the old account still transfers to the new account. The cost basis, tax information, it will also follow. But for some reason, I don't know if it's the SEC or FINRA, about 2 or 3 years ago, they made a decision that basically we had to open up all new accounts for heirs. So just trying to see, lock boxes. I can only speak from First Bank, but for lock boxes, the same holds true as a joint account. If the person's on there jointly, if somebody passes away, that other person still has access. Once again, they're just going to have a letter or something that removes the other person. You can also have a POD on that account as well. And one thing that I did bring up on Tuesday that I think is important, if you have power of attorney, this has become a little bit interesting over the last few years. And I'll kind of give you an example, and then I think the example speaks for itself. In today's society, and especially in the state of North Carolina, we have yet to find out if this is a North Carolina rule. We just know that everybody abides by the rule, whether it's a rule or not. If POAs have to have specific instructions. If you go back 5 years ago, they did not. It was basically a broad form that covered everything. Now, banks, financial institutions are requiring specifics, and I'll give you an example. So if you have power of attorney, and inside that power of attorney, there's nothing in regards to a lockbox. Well, guess what? If it's not in that POA, you do not have access. Also, if you want to change beneficiaries for a person, that's the POA. If it's not in the POA, they will not let you change it. And you can kind of understand the beneficiary side. If I'm like the POA for my wife, or let me rephrase, for my wife's mother, and I want to get rich quick, all I got to do is take my wife off and put me on, and I'd be good to go. So that's mainly the reason is for your protection, not to make things more difficult. Is there anything else you wanted me to touch on? You got it. So I'll open up the floor for any questions, and you'll have to forgive me. We have a little bit of a family emergency up in Madison that I have to attend, so I'm going to have to leave right after this. So any questions that you have, feel free to ask. Thank you.
You just did like my whole thing. I'm just kidding.
Y'all have a wonderful afternoon.
All right, hello everybody. My name is Molly Chaccio. I am an estates and elder law attorney with the firm Wyatt Early Harris Wheeler. We are right off of East Chester, across from Oak Hollow Dam. And I've been there for about 3 years or so now. And so I deal with estate planning, also estate administration. Once somebody has passed away, we help families administer estates. If there's a trust involved, we also help with trust administration as well. And then I'll kind of touch a little bit on some elder law aspects that is more like special needs planning and things like that. But I'm first going to just talk to you about, whenever we talk about estate planning, we think of wills right away. Everybody thinks of a will or a trust. So what is the difference between the two? So like Robert was saying, a will has to go through probate, right? So when you pass away, anything that is in your individual name, like any bank accounts or cars or anything like that, that is part of your estate, and it would need to be probated. So we need the original will. If you only have a will, we need the original. So the court has to have the original will to be able to determine that it is your true and real original will. That tells us obviously how you want things to go as far as, what beneficiaries are inheriting everything from you. The probate process to get the will filed and also to have all the distributions happen, usually minimum 4 months, can take longer than a year sometimes. It also depends on what assets we have in the estate. So if we have like businesses or investment accounts, that can sometimes extend things because we have to work out some kinks there when transferring those assets. So that's what a will does. So it still is a way for you to put down your wishes and say who you want to receive things, but it involves the probate process. A trust, on the other hand, is, like Robert was saying, it avoids probate. And it avoids probate if it is done correctly. And when I say that, I mean, like I said before, if you pass away and assets are in your individual name, but not in your trust, that has to go through probate. So while you're alive and you create your trust, you want to make sure that you either designate beneficiaries to your trust or you actually retitle assets in the name of your trust. So the big one is usually somebody's house. So we will go ahead and make a deed and transfer that house into the trust. You can go put beneficiary designations on your accounts to the trust. And basically anything that's in the trust when you pass away doesn't have to go through probate, and your successor trustee, the person in charge of all of those things, will take over and distribute it according to the trust document. So a reason that you would want a trust is, one, to avoid probate, right? So it's usually quicker if you have a trust. You don't have to wait the 4 months to a year sometimes to do things. You also can use a trust whenever you might have some sort of tax issues that we want to plan for. The big one is the federal estate tax. Very few people right now have a taxable estate whenever they pass away because the exemption is about 13 million right now. So you do not get taxed on your estate unless you have more than 13 million. If you do, we should talk. So we're not really worried about a whole lot of estate tax planning now, but in a couple years, maybe it'll go down. Who knows what they're going to do with it. And then some of you might actually be needing some complex tax planning built into some trusts. And so a trust is a good vehicle to do that. A trust is also a good idea if, let's say, for example, you want to control things a little bit more when you pass away. So you want to leave your son a bunch of money, but he's not the best person when it comes to financial decisions, right? So you can actually leave it to him in trust and then even control where it goes once your son has passed away. So we joke around sometimes and say it allows you to kind of have more control from the grave, if that's what you choose to do. And as far as, like I was saying earlier, like special needs planning and things like that incorporated, if you have any family members that maybe they're on Medicaid or disability or they have something that they're receiving a government benefit, and if they have too much in assets, it'll disqualify them. We can use trusts, special kinds of trusts, to make sure that you can still allow those family members to inherit from you and protect them so that they can use that money but still qualify for their public benefits. So there are some options there we can use as well. So that's basic will versus trust. There are some people, I know I had a question last time about, well, what about a testamentary trust? So that is a trust built into a will. Some people will still have just a will that has to go through probate, but they want to put a trust inside of the will instead of having it their own trust. That's fine, we can do that. But again, that would have to go through probate for that trust to be funded. So sometimes it's just better to have just go with the trust route and handle that right up front. So another part of the estate planning process, like Robert was saying, was beneficiary designations and titling your assets. So we want to get an idea of how your assets are titled, whether they're titled jointly, individually, who they're titled jointly with, and who your beneficiaries are. A lot of people have primary beneficiaries, but they don't have contingent beneficiaries. So what if something happens to that primary beneficiary? To avoid that asset from coming through an estate and probate being required, we want to make sure you also have contingent beneficiaries built into your assets. Okay? So that's what everybody thinks of when they think of estate planning, is what happens when you pass away. But sometimes an even more important aspect of estate planning is, well, what happens when you're still alive and something happens where maybe you're in an accident, or maybe you have a dementia diagnosis and you get to the point where you can't handle your own affairs anymore. We do what are called powers of attorney. So there's the durable general power of attorney, which is for finances or legal affairs, and there's the healthcare power of attorney. And so in these documents, you appoint people that you want to be able to take care of your assets, both financial or healthcare, so that if you need help, it could be as simple as you're stuck in the house sick and can't get out and need somebody to go to the bank for you, or you actually are unable to make good decisions or communicate and things like that, and you need help. If you do not have powers of attorney and your family needs to come in and do something for you, oftentimes they have to go through a court process to get what's called guardianship, and that can be lengthy and pretty expensive. So powers of attorney can be very, very important. And just one important note about powers of attorney: whenever you pass away, the powers of attorney become null and void. So some people, after they pass away, their power of attorney decides to try to do something and say, oh, I'm power of attorney, I can do that. But actually, when you pass away, it goes to the executor or the trustee rather than the power of attorney. Those documents are no longer usable once you've passed away. We do recommend that you review your estate plan every 3 to 5 years. So all those documents that I just talked about, if 3 to 5 years, look at them, see who you've named to be in the important roles, who you've named as your power of attorney, who you've named as executor of your will or trustee, and just make sure that people are still alive. If people are maybe older and you're unsure if they're going to be able to help you as well as you would want them to be able to help you, you might want to consider changing them. And just make sure that no big life events have caused some sort of wrinkle in your estate plan that needs to be ironed out. So we just recommend keeping them up to date and looking at them every few years or so. Right? And like I said earlier, I know Robert talked about safety deposit boxes. If you have a will and you're going the will route and you don't have a trust, like I said, the original will is extremely important, because if we don't have the original will and all we can find is a copy, then we actually have to go through a court process that requires a hearing in front of a judge and can get kind of messy, because everybody in your family usually has to be noticed about the hearing, and it's just a really good idea to keep track of your original. And so regarding safety deposit boxes, we don't recommend keeping an original will in a safety deposit box unless that deposit box is jointly owned with your executor, or your executor is the beneficiary of that safety deposit box, because if not, we have to get the document in the box to be able to appoint somebody the executor, but they can't get in the box unless they're appointed executor. So we find ourselves in a catch-22. So just try to plan that a little bit better. But all right, does anybody have any questions? Yeah.
Everything needs the original will.
I said, who needs the original will?
You said everything needs the original will. Well, isn't the original just one?
Mm-hmm.
How do you get that one will to everybody that needs it?
So the question was, who needs the original will? How do you get that original will to everybody that needs it? The one that really needs the original will is your executor when you pass away, so they can file it with the court. You don't have to give your will to anybody else, and I actually recommend that you don't. Some people might say, well, what about the beneficiaries? They don't need your will. If you want them to know what they're inheriting, then that's fine, depending on your family dynamics. But we usually recommend that you make sure your executor knows where that original will is. Give them a copy maybe, so they also have that. But the only time that original is going to be needed is when you pass away to file with the court. Yes.
Does that also apply if you've registered your will with the register of deeds or county register?
Yeah. So you can register your will. When I say register, it's more so like file it for safekeeping is what they call it. So if you've done that and the court has your original on file, then that's fine, and they already have it. So that'll make things a little bit easier. The only hiccup I sometimes see with doing that is some people will do that and then they'll make a new will like years later and forget that that original will is already filed somewhere. And then, heaven forbid we lose the original of the new will. And so we're kind of stuck with an old will, or it can be messy. But if you're absolutely sure that your will is perfect and you're not going to change anything, it's not a bad idea to make sure they have that. Yeah.
Can you please touch on because there's so many blended families now, can you touch on stepchildren, et cetera, and maybe you don't want some of them to be remembered?
Okay, so the question was about blended families and stepchildren. Are you saying that maybe you don't want the stepchildren to inherit anything from you?
That's right.
Okay, so the most common scenario that happens is we've got a blended family, maybe second marriage, right, where they have kids from prior marriages. If you still want your spouse to be able to inherit from you, but you don't want their kids to get things in the future. Let's say when your spouse dies, if you die first, everything will go to your spouse, but then you don't want your spouse to be able to leave your stuff to their kids. That is a common scenario that we would either include a trust inside of a will, or we would use the trust vehicle and include like a trust inside of the trust per se. So what we would do is we would want to leave everything to that spouse in trust so that the spouse would be able to use it for their benefit while they're alive. But then when they pass away, you direct where it goes so that they don't have any control over where it would go when they died. So kind of what I was talking about, controlling from the grave, that's a very common scenario that often comes up, and that's the strategy that we use. Yes? If it was written in another state according to that state's laws and it was perfectly legal when it was done there, then yes, it's usually still good, and it's enforceable in North Carolina. What you want to consider, though, if you maybe moved from that state to here and you don't have any assets left in that state, you might want to consider just updating the trust to North Carolina law, or else you might be or your trustee might be trying to distribute your trust assets and be bound by another state's law if they're trying to distribute in North Carolina. And that's just usually a simple amendment that can be done. Yeah. Yes?
If you update a trust, needs updating, how do you charge for that? Would that be fee-based or?
So the question was if updating a trust, how would we charge for it? Would it be fee-based? So it would depend on what we're updating in the trust and how much of the trust needs updated. If we're going to do like a complete update to the entire thing, we sometimes call that amending and restating the trust. We sometimes just charge hourly for something like that. If it's just a simple amendment that maybe will take like a couple page amendment to, supplant something, replace a provision somewhere, we might do that flat fee. I can't really give you, unfortunately, like an idea of how much it would be unless I know a lot more details, but yeah. Yes, in the back.
The lawyer that did my will for me and POA and all that important stuff is right here in town. I did that when I moved here from New Jersey 5 years ago. She didn't mention anything to me about setting up a trust. I have one single family member that will be getting and taking care of everything for me. Do I need to have a trust set up?
So without talking more, I can't give you like a hard and fast yes or no, but I will tell you in those types of scenarios, when you have just usually one family member and you just want that one person to inherit everything, it's not uncommon to only have a will. Because while a trust will avoid probate and all of that, you also can avoid probate by making sure that your beneficiary designations are correct. You have PODs and TODs, like Robert was saying earlier. So in your specific scenario, a lot of the times a will makes the most sense. And if you have bank accounts or other assets that allow you to put PODs and TODs on them, put that family member as that beneficiary, and then they likely wouldn't have to use the will anyways. So there is a trust isn't always the most economical option sometimes, especially when you have a really simple situation like that. There are other ways around it. So I would say, I mean, you wouldn't necessarily need a trust as long as your beneficiary designations and all of that are to that person.
One more
Mhm.
add on to that.
Yeah.
My daughter lives in Vermont.
Mhm.
At what point would be a good time for me to put her name on my checks so that she can take over writing checks for me?
So, if you have powers of attorney, what I would recommend doing is, as soon as you want to, go to the bank with the document. Usually that person has to go along with you if they're going to be doing transactions or writing checks and whatnot. We recommend putting them on your accounts as power of attorney, not as a joint owner. And some people, there might be different opinions about that. But one of the big reasons that we don't recommend putting people on as joint owners is because when you do that, it can open up at least half of the money in that account to that other joint owner's creditors if they were ever to get a divorce. And so there's some extra liability built in there that we just don't always want you to have to worry about. So I would say, I mean, as soon as you want to and as soon as it's convenient, I would go ahead and do that, but I would put her on as a power of attorney rather than a joint owner so that she has all the authorizations she needs to access and write checks, but she's not an official owner of that account.
That's what I did when my mother died. I was an only child,
Okay.
and we did that a few months when the cardiac doctor said she only had a few months to live.
Mm-hmm.
And I went with her and changed all that stuff, and then I didn't live right by her, so I took the checkbook home with me, and then all the bills were being sent to me.
Mm-hmm. Okay.
Is that a good idea to do that?
Yeah, I mean, that's not a bad idea. I'm not sure in your scenario you would want to do that right now because you seem perfectly fine to be able to still manage your own affairs and everything. I don't know all the details, so I'm just assuming there. But so it wouldn't be a bad idea, but putting her on that account would also give her the ability to change those things too if she needed to. So if you needed them to start going to her, she could go ahead and change that so she'd be the point person.
So my mom, if the account was made, it was just being started down at Zerka, POA.
Mm-hmm.
So would I do the same thing with my daughter?
Yeah.
Would be my name, then her name with POA after it?
Mm-hmm. That's typically how it's done. Yeah.
Thank you.
Mm-hmm. Any other questions before I leave? I'm sure I'll be up here too if you have other questions once everything is over, so I'll hang out for a little bit. But thank you.
Good afternoon. My name is Megan. I'm a nurse with Hospice of the Piedmont, Hospice of Randolph, and I'm a long-term care liaison. So my topics is not always something that it's easy to talk about. Most people have experienced hospice for a loved one, but there are people who have not. So just a little bit about hospice. Hospice is for people who have a very serious illness that is now terminal, meaning that you're not improving. You may have gone to the hospital multiple times. You've seen your physician multiple times, and there's not much more that they can do for you as far as to cure the illness that you have. So they may tell you, we're kind of out of options. There's nothing else we can do, but you're not quite out of options yet. So what these serious illness can look like, when people think of hospice, a lot of times they think of cancer patients. But we serve many more diagnoses than cancer. We serve heart failure, COPD and lung issues. We serve dementia. We serve liver, kidney disease patients. And what it does is when going to the hospital is no longer helping and you choose to elect hospice services for your medical care, you're now in control and you get to choose care on your terms. So whether hospice can serve you in many capacities, they can serve you at home, they can serve you in a nursing facility, an assisted living facility, and we also have an inpatient unit, which we kind of call our mini hospice hospital. So there's many areas you can be served, but what it does is it allows you to be where you're comfortable and where you call home, whether it be a nursing home or your personal home, independent living apartment, wherever it is. It allows you to be surrounded by your family and those who mean the most to you. And what we do is we manage your symptoms at home. And we help you feel the best that you can feel with whatever your condition is. If something is causing you shortness of breath, we help manage that to keep you as active as long as we can. One thing that I didn't get mentioned on Tuesday I want to share with you all. Anybody who has Medicare, within Medicare lives a hospice Medicare benefit. So you have already put into that hospice benefit. So that means if you ever at a point where you have a terminal illness and you need hospice services, Medicare will cover it at 100%. There is no out-of-pocket cost for the nursing visits, for the hospice physicians that help manage your medications, manage your symptoms, for the CNAs that can come out and help you do a few, with your dressing, your bathing, if you need a little help with your shower. You guys have a wonderful spiritual care program here, but we do offer an additional layer of spiritual care if you need it. There's social workers as well that if you need help with any community resources, any of these documents, they can help set up a lot of things as well. And there's also volunteers that can help provide companionship. So all of those live under that hospice Medicare benefit, and it is of no charge to you. We also help pay for medications, for any supplies you may need, incontinence supplies, any equipment, if you need a hospital bed, if you need oxygen, if you need a wheelchair, if you need a walker, we also provide that to you at no cost. So, and then one thing that also helps is it helps your family. It helps those that love you and are taking care of you. Not only do we walk the journey with you and help you be as well as you can be and feel as good as you can be, we help your family navigate a difficult time as well. We support your family. We're on call for you and your family all the time. And we can help your family know kind of where you're at, where things are looking, and what they can expect. Now, there's a lot of you out here that you may say, well, I am nowhere close to this. I'm doing well. I'm active. But I always say anything can happen at any time. And so if there's anything I could leave you today, I would recommend, while they're hard conversations, have conversations with your family now, what you want your care to look like if something happened to you and you couldn't speak for yourself. If something happened and they found that you had passed away, how far would you want somebody to go? Would you want them to do CPR? Would you want to be on a ventilator? Would you want to have machines breathing for you? Would you want to be on dialysis machines? Do you want a feeding tube? Those are things that's hard to think about when we're doing well, we're up moving, we're getting out and about, we're participating in different things. But when crises happen, and sometimes we can be healthy and we can't avoid them, there's high emotions. People are upset, they're worried, and it's hard to make decisions in those moments. And the thing that I have seen in my 7 years of working in hospice families is there's a lot of peace that comes for your family when they know what you want. Because if they can say without a shadow of a doubt, my parent wouldn't want this, my loved one wouldn't want all this, and they know that you don't want that, there's such a peace in a difficult time. So while they may be hard conversations, I cannot stress enough, that's a great thing to talk to your family about, to let them know what you would want and empower them to make decisions based on what you would want only. So that would be the biggest thing that I can take away. And one other thing too that comes with a hospice program, no matter where it is a bereavement or a grief counseling. Once you pass away, your family has access to grief and bereavement services for 13 months. That helps them get through major holidays and then the anniversary of your passing. So your family is well supported. We have specialized children's grief camps and programs. So we're also there. It's a great support for your family even after the hard days and finding a new normal. We're there for your family as well. So I know probably not many questions for me, but if there is any, I'm happy to answer them. Yes, ma'am.
Do you have the forms available for, the power of attorney, or not power of attorney, but the healthcare, et cetera, on what you want and the living will, et cetera? Do you have those?
I don't have any with me, but there's two forms, main forms that we use in end-of-life care as far as a medical form, and both of them need to be signed by your physician. One of them is a do not resuscitate. It's a golden form. So that means that if we come in and we find that you have already passed away and it's been a natural cause, that we do not attempt CPR and to revive you. Now, that's different to say if we come in and your heart's still beating, but maybe you're having trouble breathing, or vice versa, that we wouldn't do anything. But that one says if you are completely gone, heart stopped, you're not breathing, just to let you go. The second form that I would recommend is called a pink most form. It's medical orders for sustaining treatment, and it's a pink form. And I'm happy to drop some by that you can take and go over with your doctor. And that gets down to more, okay, it answers the question, do you want CPR if you're already gone? But it talks about if you're in the hospital, how far do you want them to go? Do you want critical care? Do you want ventilators, breathing tubes? It breaks down, there's 3 options there for when you are in the hospital. How far do you want them to go? It'll handle things like, do you want a feeding tube? Do you want IV fluids? Do you want IV antibiotics? It goes more into detail, and it's a pink form called a most form, and it's signed by your physician. So it will be recognized at hospitals. Both of those forms are. I'm happy to drop some by this end of this week or beginning of next week that you can pick up from and take with your doctor, and you can go over it with your doctor, your family. I do recommend, if you're interested in that, go over it with your family so they know as well.
Question,
Yes, ma'am.
is the pink form state specific?
No, I don't believe a most form, Molly. A most form is not state specific, I don't believe. Okay, it should not be state specific, and because there are lines also to put anything that may not have been covered in those main topics that you would or would not want as well. Yes, ma'am.
I have a medical power of attorney that is specific.
Mhm.
Does that still have to be signed by my physician?
No, power of attorney do not have to be signed by physicians. And a lot of times, if you don't have that most form I was just talking about in place, they're going to look to your power of attorney if there was a crisis on what to do. So that's why I recommend talk to your power of attorney about what your wishes are if you couldn't speak for yourself medically, to how far that you would want them to go, what kind of treatment. And that may change. Right now, you may say, whatever you can do, give it a try. But that may look different if you have, if you have heart failure that's advancing, or you have, later you get diagnosed with cancer. That may look differently too as things change and situations change. But always have those conversations for sure. Yes, ma'am.
Can you have dual power of attorney?
Yeah, that's different from healthcare, so I'll direct to Molly to answer that.
Do you mean like 2 people? Okay, yeah. Yeah, so there are 2 ways that you can do that. You can have them, we call them co-agents. So they can be co-agents where they both have to agree on everything and they would both have to be present. Or there's co-agents where they can each act independently of one another, but either can be called on if they're needed, if that makes sense. So yeah, you can do that a couple different ways.
So I wanted to ask a question. You were
Sure.
talking about the most form and the DNR. Do you have to have both forms? Or like if you have a most form, can it also act as that DNR?
So I would not have a most without a DNR. If someone comes in and they find that you're passed and you do not want them to start CPR, I would make sure the most important thing would be to have that do not resuscitate, a gold form. You can have both, but I definitely would not, if you do not want to be resuscitated or have CPR if you're already gone, I would recommend having that yellow gold DNR form.
And I just want to mention, you said you'd bring the forms over to us, and we would appreciate that. But I also want to say you can get those forms in the clinic.
Yes.
So many of you are patients of Dr. Blake and make that very, very easy to have those forms completed. And it's really important, if you do have a DNR, that be someplace preferably on your refrigerator, in your apartment or in your cottage, so that when our emergency personnel come in, they immediately see that DNR. So, but all of that you can talk to Sandra Loy and to the nurses in our clinic about.
Yes, yeah, definitely the most center part of your home is where I would have that to be seen. Some people have put it over their beds, but you may not always be in your bed when something happens. Okay.
Now I have one more question,
Sure.
see if you can answer this. Will emergency personnel, EMTs that are coming with the ambulance, will they always honor that DNR, or are there situations where they will not?
They will always honor a DNR, and most likely they will, if you have that most form with it. What I would do is I would recommend getting like a sleeve and putting if you have a DNR or that most form that says, I would put those together. They will be honored because they stand as physician orders because they are signed by a physician. Sure. She asked if you can have conditions on a DNR. I've never seen conditions on a DNR. And the reason is that DNR serves if you're already gone. If we come in and find you already gone, we would not start CPR to revive you. The conditions where those would probably come into place, you would want to look at a most form, where we talk about the feed and tube, how far as breathing machines, IV antibiotics, IV fluids. There are some places there where you can fill in other things. And those are going to apply if we come in and you're still alive, but maybe you're not breathing or maybe your heart's not doing well. That will play in when you're still alive. MOST.
Tell them what it stands for again.
It stands for Medical Orders for Sustaining Treatment. They're hard conversations, but worth it completely. Okay, anybody else? And I'll be here after as well if anybody has other questions.
Good afternoon, everyone. My name is Alexis Plunkett. I am a licensed funeral director. I am with Secrease Davis Funeral Home. If you've lived in High Point a long time, then it used to be Secrease, it used to be Davis, and now we are combined into Secrease Davis. Another thing that we are very proud of this year is that our funeral home was selected by the High Point community as the best funeral home in High Point. So that's something we're very proud of. But the main reason that I'm here today to talk with you is to talk with you about the importance of planning ahead. I began my career in funeral service by serving families at need. So that's folks that have lost somebody that they love, and they would come into the funeral home, make arrangements with me. We would carry out the funeral services, and that was the case. Now, having done that role, I saw there is a difference between folks that have a plan in place before they pass away and those that do not have a plan in place. And I feel very, very passionately that we should all have a plan in place before we pass away. And so for that reason, my role now is to help people to put that plan in place ahead of time. So I want to mention, there's a lot of reasons to put a plan in place ahead of time. What it really boils down to are the two reasons, which is the logical reason, which is financial, and then the emotional reason. So I'll start with the logical reason to plan ahead. So when we talk about planning ahead, the financial reason to go ahead and have your funeral arrangements taken care of is you can actually freeze your funeral arrangements in time. Now, funeral services are no different than any other industry. Our costs are going up with inflation. So if you choose to arrange your funeral services ahead of time, for example, our cost for direct cremation right now is $2,455. 10 years from now, I promise you it's going to be more than that. So if you're planning on kicking around, and we hope that you're all going to be with us a very long time, it is a good value to go ahead and lock in that cost so that you can protect it against the rising cost of inflation. So that is a good financial reason. And to give you an example of that, when I served families at need, I had this one case where they came in, their mother had prearranged in 1997. She passed away in 2023, and they did not have to pay a dime to the funeral home. Instead, they received a check back, okay? So that is a huge benefit versus having to pay, $10,000, $12,000 is what her funeral would have been if she had not paid for it ahead of time. So there is a good financial reason to do it right there. But then what hits most people is the emotional reason to do it. So I'll start with the control freak side of things. I myself like to be in control. I know what I want and I make it happen. If you are like me, then you want your wishes laid out so that it's no guessing for the people that you're leaving behind. But then on the more emotional side of it, it is good to have this laid out because you don't want your family guessing. Aside from helping people plan ahead, I also serve our families by providing the aftercare support. So I will go out to their home if that's what they would like, give them some grief support materials, checklists that they may need to handle the estate matters. But then I'm also going to speak with them about their feedback. And I met with a gentleman recently who he was very pleased with the services that we provided, but he expressed to me that he and his mother did not ever have this conversation about what she would like before she passed away. And at the time that she has passed away, he had no idea what to do, so he did what he thought was best, what he thought was prudent, and he ended up going with simple cremation. Now, we can't say for sure what her wishes would have been, but that's exactly what we don't want your family to feel, is we don't want them to feel concerned that they didn't do what you want. We want it all laid out. So there's a good emotional reason to do it as well, which means that you are protecting your family from making those hard decisions in a time where they are grieving at the loss of someone that they care about deeply. Now, when we talk about planning ahead, it can seem very stressful. I mean, we've talked about a lot of reasons and things that you've got to do to get prepared, but we have broken the funeral service process down very simply. So it's 4 steps. The first step is we're going to reflect. That's where we actually sit there and talk about what you want for yourself, what you see for yourself. Some people, they have the perspective, well, I'm not there anymore. I don't have to worry about it. We'll just go simple. Other people say, I lived a great life on earth and I want everyone to celebrate it. And so we go that route. But the first step is to reflect. Think about what you want. The second step is record. So that's when we're actually going to take the point of writing it down what we want. We, the funeral home, when we set an appointment with someone, we will bring to them this personal planning guide. I tell people, even if you don't want to fill out this whole book, because that can be a lot, this first page here is the most important because that is the information that any funeral home will have to have for your certified death certificate. And as much as our family members love us, sometimes they do not know this information, sometimes they do not have access to this information, or sometimes they just forget it because they're grieving. So I tell people, fill this out, make them a little cheat sheet, that way they don't have to think about it, it's already written down for them. But this booklet gets very specific, talking about service preferences, cemetery preferences, financial accounts. Maybe you're a member of a civic group and you want that civic group to know when you've passed away. There's a place in here for all of that. We also have a veterans planning guide. Are there any veterans in the room today? Thank you all for your service, first of all. But then I want to mention to you, there are a lot of common misconceptions about what is covered for people that have served in the armed forces, especially when it comes to funeral services. Many people think that everything is covered, and I can tell you that is not the case. Generally, the most you can expect if you would like to be buried in a national cemetery is that they are going to cover your plot, that's the space. They're going to cover your marker, which is noting where the grave is. They're going to cover the vault, which is what houses the casket. and they're going to cover the opening and closing of the grave. But you got to get to the cemetery first. So that is why we tell people it is important to speak with a funeral home even though your cemetery is covered ahead of time. But this booklet for veterans goes into all of the benefits that they are entitled to, because there are more than just those cemetery benefits. For example, this book does have, if you can't locate your discharge paperwork, there's a copy in here so you can get new. If you, for example, wanted a letter signed by the president of whoever it is by the time you pass away, you can get that for your family in here. So these are great resources to have. I also brought a couple of handouts with me as well. This one in particular is for veterans that talks about the 10 important facts they need to know about their benefits. So if you don't want to read through this giant thick book, I got a little handout for you. But then the next step after we write it all down, what we want, is to actually secure it. So that's when we talk about financially guaranteeing those prices. Now, when the time has arisen and someone has passed away, if they have not paid for things ahead of time, all of that money to the funeral home is due prior to services rendered. So if you are being buried and your funeral bill is $12,000, your family will have to pay $12,000 before we take you to be buried. That can be a huge obstacle for a lot of families, especially if you don't have life insurance, especially if you don't have any money that they can rely on, through power of attorney or anything like that. So when you pre-arrange, you don't have to pay it all up front. You can, of course, but you can actually make payments over time if you wanted to go ahead and lock in those prices and you just can't afford to do it all at once. But you can make payments over time, so that gives a little bit more flexibility to people that want to take care of this ahead of time. And so then the last step, once you've secured and taken care of all of these things, is you want to share. You want to share it with whoever is going to be handling these arrangements for you. You want to share it with your family members. And I tell people, we kind of hit on a lockbox situation, but even just having a simple safe. If your family does not have access to get into that safe, guess what good all those papers in there do? None. It doesn't do any good for them, and then they have to call a locksmith. So make sure that your paperwork that you are leaving behind for your families on all the things that you have taken care of, make sure that it is accessible to them. Sometimes that means, leaving a sheet of paper with passwords, for our phone. I can't tell you how many times I've seen where family members are trying to get into their loved one's phone and they just can't. So making sure that the things that we leave behind that we have taken care of are accessible to the people that need them. That's another very important thing. So talking about, reasons to plan ahead, we've talked about it a lot as far as the emotional and logical reason. Some people say, well, I'm not sure that I want to do that yet because I might move. Well, if you win the lottery tomorrow and you're headed to Florida and you've prearranged your funeral, it can move with you. You can transfer that funeral to another funeral home. So let me talk a little bit about that. The legal law is that the funeral home does not have to honor it, but any respectable funeral home is going to honor it. So for example, we have received contracts from other funeral homes in the area, and they are marked inflation proof, and we are going to guarantee them nonetheless. Even though they were not written with our funeral home, we are going to guarantee them just the same. So any respectable funeral home will honor a transferred contract. So if you're not planning on sticking around in High Point, you can take it with you, okay? And so that's really going to be the main thing ultimately is, this is something that none of us can avoid. So it just makes sense that when we plan for all these other things in life, that we would plan for the thing that we know is going to happen, which is our passing. We do want it to be as easy as possible on our loved ones. We do not want them, left at the end of the day either worrying about how they're going to pay for this or worrying that they did the right thing. So at the end of the day, you just want to make it easy on your family and let them know what your wishes are and take care of it ahead of time. Does anyone have any questions for me? Yes, ma'am.
I've often wondered, is there a insurance on this contract? I mean, what if the company goes out of business?
That's a great question. Sure. So the question is Is there insurance on this contract? What happens if the funeral home goes out of business? So yes, your monies that you pay for a funeral, they are held by an insurance company. So not only are they held by an insurance company to protect you in case the funeral home goes out of business, but that means it's also growing over time. So your policy is going to be increasing the longer that you live, and we hope, like I said, that you're going to live a long time. So it is protected against the business going out of business, and it is also protected and growing as well. So, Any other questions? Oh, yes, sir, go ahead, sir.
What type of arrangements should be made if the burial is going to occur in a different state?
That is a very good question. So when we're talking about a burial to occur in a different state, are we referring to you will be cremated and then transferred and buried, or full traditional burial?
I think it would be a cremation.
Okay. So either way, what we would want to plan for is getting you to that other state. So in the example of, say, we are going to be cremated and then interred or buried in a different state, what we would want to plan ahead for is, first of all, our cremation. That has to be taken care of. Second of all, we would want to pay for shipping. Now, there's two ways to go about it if they're cremated. If they're cremated, someone can technically carry that on the plane with them. You don't have to worry about paying for anything extra in that way. They would just take it onto the plane with them directly. They would have what's called the certificate of cremation with them, just so that no airline personnel are opening up your urn. That's horribly inappropriate. So we would give you the certificate of cremation so that you can just carry it right on the airline with you. Now, if there is no one that's there to take you physically to that other state, what we would do is probably mail the cremated remains to a funeral home nearby that cemetery that you wish to go to. And so cremated remains are required by law to be mailed by the United States Postal Service. They are required to go via express mail so that they get there within a day. And they do require a signature as well. So that's why we would probably do the funeral home as opposed to someone up there. So that would be if we were going to be shipping someone that is cremated. It is a little more complicated if we're talking about, you live down here in North Carolina, but you were born in, for example, New Jersey, and you want to go back to New Jersey. Then what we would want to plan for is, it is required by law, if you are going to cross state lines, you have to be embalmed. So that is one thing that you would want to prepare for. Another thing would be that you have to be shipped via airline. So you would either have what's called an air tray and a casket. So the casket houses the body, of course. The air tray houses the casket so that it does not get damaged. Or we could do what's called a combination unit. So if you don't want to get your casket down here in North Carolina and you want it to be from that New Jersey funeral home, you can just get a combination unit. And that combination unit is just simply the body in the container being shipped. So you would have to basically prepare for all the stuff that you need down here, which is primarily basic services of the funeral director and staff, which is all the background stuff we're doing, like filing the death certificate, notifying Social Security. But then you would want to account for embalming, which is required to cross state lines. And then you would want to account for that container that houses the body, and then your airline ticket as well. So it's a lot. It's a lot that goes into it. And so that's why I recommend people how important it is to go ahead and have these conversations ahead of time. Was there another question? Yes, ma'am.
It's probably for all of you. I'm curious if you've heard about 5 Wishes organization and if you have any insight as to them and their resources and tools or not.
I have not heard of this organization. Now, I have only been in funeral service for a few years now, in case you couldn't tell by my age. But I have not heard of this organization, but I would be definitely glad to look into them. Do you know anything about them to kind of?
Yes, I can talk to you later.
Okay, sure, that would be good. Wonderful. And so one last thing that I wanted to hit on, because it was kind of touched on a little bit here and there, is power of attorney. They've mentioned that, when you pass away, power of attorney ends. So if you are anticipating that your power of attorney is to make the disposition decision, meaning they will be determining if you are buried or cremated, then that has to be specified in the POA. Because while it does end on death, if it specifies the right to disposition, that still holds true. Okay? Yes, sir.
What if you wanted to donate your body?
So even if you donate your body, you still end up contracting with a funeral home. Because most of the time, anatomical donations, it's very rare that they will accept a whole body donation. Most of the time it is organ or tissue that they are taking. And so they will actually come physically into the funeral home that your family has contracted with to collect that. Okay, I think that's it. Thank you all so much, and I do have handouts if anyone would like one.
Thanks so much to all of our panel today. If you've heard anything or learned anything, I would say what you really need to take from today is that you really need to have all of these conversations. You know, if you've made all of these plans, but you haven't shared them with your executor, you haven't shared them with your children, then the plans there's a chance that they may not go the way that you had worked through them. So I hope that all of you will think about this and take time and have these conversations. The last few minutes of today, I just want to share with you what happens at Pennyburn when you pass away. One of the things that we've learned over the years is that it's not one size fits all. Everybody has a different idea of what they want to see during a loss. Maybe you're a spouse and your spouse passes away. Some of you don't want people to immediately knock on your door. You don't want to hear from somebody right away. Others immediately want that support. So we really try to be very sensitive to those of you who lose a spouse and even friends. You know, one of the things that's just a reality of this type of community is that we do go through a lot of loss. And I know everyone that I've ever spoken to has said it just means so much to have the support of those that are around us. One of the things that happens when you pass away or any one of our friends is that immediately our pastoral care team, which up until now has been our sisters, will be in touch and really try to identify what help you need, what is important. Moving forward, we'll still have a pastoral care team that just looks a little bit different than our sisters. So we're confident that those same services, that same support that you get from them is going to continue. The other thing that will happen is that you'll hear from some of our department heads. A lot of times you'll hear from all of them at different times. I'm typically one of the first people that someone will talk to after someone passes away. So it's really, really important that we know exactly what your wishes are. One of the ways that we make sure that we honor what you want is we actually put an estate lock on the door once there is no survivor in the residence. And the only person that has access to that residence, whether it be apartment or cottage, is going to be your executor or your trustee. So it's really important that I have that information. A lot of people wait till they don't provide it ahead of time, but I will tell you, if you can go ahead and give me that information, it is kept in a very secure place. And even if something were to happen to me and I would not be here, my coworkers that would be involved with this know how to access that information. It doesn't require that I have your entire trustee document or your entire will. All it requires is that I have the page that identifies what it is, and then the page that identifies who your trustee or your executor is, and then the last page just showing that it's official. So usually with the stamps and whoever has witnessed that. So that is who we provide the estate key to. One of the questions I get a lot is, well, do you have to change the lock? Do you have to put an estate lock on? And the answer to that is no. And there have been several situations where we didn't change that, but it was because we had the information. We knew exactly who the executor was, and the executor was said to us, you don't need to change that lock. I'm the only one that's here. I'm the only one that's going to access what is in that residence. So if we're asked to do that, we certainly want to honor those wishes. So as I said, it's really not, in terms of what happens here, one of the questions we got the other day, let me just answer this, was how long does it take, how long do your executors, your trustees have to vacate your residence? Most people take 30 days. I will tell you, I think twice in my 23 years here, I've seen somebody take a week, and that's pretty fast for something like that to happen. We typically, like I said, say take at least 30 days, but if it goes beyond that, just keep in mind that the estate continues to pay for your residence until everything is out. So if it goes beyond that 30 days, then it's just prorated for whatever extra time you have to take. I will tell you, we've had estates that took us 6 months to clear out. So, and a lot of that had to do was because they did not have that original will. And then in another one, they appointed an executor that was pretty much their same age. And so at that point in time, that executor really couldn't serve, so was not able to do so. So it's really important that as you're having these conversations, you think about those things. Think about who you can anticipate to be around at the time that you pass away. And that's not always going to be a child. It may be a great-grandchild, maybe even great-nieces, great-nephews, or maybe even an attorney. So, or a trust officer, which they occasionally serve in those roles. So I am here to help all of you with whatever you need. I'm even willing to help you have those conversations with your family. So if that's something that you would like for me to do, we just have to get in touch and plan that. Any particular questions about what happens at Pennyburn when you pass away? Yes?
Can your executor stay in your apartment while the process is going on?
We prefer that they don't, and let me tell you why. We actually, if you've read very thoroughly your handbook, it says that nobody should be in your apartment when you're not here, and that remains true when you pass away as well, because they're not residents, and so they don't know all the ins and outs of living at Pennyburn, and yet at that point they're going to be responsible. I will tell you there have been a couple of instances where we did make exceptions to that. So if there's a unique situation, we can certainly work with you on that. And I think that's what Pennyburn always tries to do. We have specific guidelines, but we also want to work with the individual if their situation might be a little bit unique. The other thing that I didn't mention was you can also have your service here. We have had funeral services in this very room. And you also can have a service in the Maryfield Chapel. We do have guidelines for those, and when the time comes, if that's something that you want, I have all of that information available. Any other questions, whether they be for me or for any of our remaining panel? Well, I hope that you have found this informative. Thank you for being here. And again, we'll all be here, so if you have any other questions you want to ask privately, we're happy to do that. Thanks for coming.